orders immediate release of Saminu Turaki from prison. Chief Justice of Nigeria performs groundbreaking for judges' quarters in Rivers State. Plus, INEC seeks court injunction to recall Kogi West Senator Dino Melaye. It's a pleasure having you with us once again on Judiciary Watch. I am Augusta Yaku. On today's episode, we will be discussing asset declaration in public service and its practicability in Nigeria. Joining us on this is legal practitioner J.J. USMAN.
A man has acquired illegal assets while he's in the office, and this brings integrity into the institution. This brings confidence into the to the public. It's a kind of checkmating illegal acquisition of asset by a public officer.
All the details in just a moment. Please don't go away.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like it.
The former governor of Jigawa State, Ibrahim Saminu Turaki, has finally been released from prison's custody. The Federal High Court Abuja had earlier Thursday morning ordered that the former governor be freed. The ex-governor had filed a motion for the Economic and Financial Crimes Commission to be removed from the parties that will verify authenticity of the documents contained in its bail conditions. The presiding judge, Justice Nnamdi Dingba, granted the motion in its entirety and ordered all parties to comply with immediate effect. Saminu Turaki has been remanded at the Kuje prison, Abuja, for more than a week after he has met his bail conditions. He was arrested by the EFCC on the 4th of July at a book launch in Abuja and has been remanded in custody. Justice Nnamdi Dingba of the Federal High Court, Abuja, has granted ex-FCT minister's son permission to travel abroad for medical treatment. Shamsuddin Bala Mohammed is being prosecuted on 15-count charge of money laundering to the tune of 1.2 billion naira by the Economic and Financial Crimes Commission. Despite vehement opposition to his travel request by the EFCC counsel, Ben Ikani, Justice Dingba allowed Shamsuddin to travel on grounds that Shamsuddin has always adhered to court orders.
At the resumed hearing on Friday, counsel to Shamsuddin, Kanayo Okafor, presented to the court a motion on notice dated 24th of July 2017 and filed on 25th of July 2017. The motion seeks for an order of the Honorable Court to enable his client travel to United Kingdom for medical appointment. But in a vehement opposition, EFCC's counsel Ben Ikani told the court not to grant the application on grounds that Shamsuddin has not presented previous medical history that shows whether his ailment cannot be treated in Nigeria.
Okay, it's an application for an order of the Honorable Court to enable our clients travel to the United Kingdom for medical appointment. It's an innocuous application. It has been granted a similar application sometime for Lesser Hajj. He traveled, came back. This time around, an issue of health came up. So the court graciously granted him. He's coming back before the next trial date, which is on the 20th of September. For
EFCC's counsel Ben Ikani, his reason for opposing the application is in compliance with the Administration of Criminal Justice Act.
Why should issue of medical be dangled? But like his lordship said, anybody who tells lies about his medical situation is left to him and God. But we, EFCC, we are ready to obey court orders and we are ready to prosecute in accordance with the procedure of law. That is my quarrel. That these are flimsy excuses.
After taking argument from both counsels, Presiding Judge Nnamdi Dingba told both counsels that it is in his view to grant the application, given that the applicant has been compliant with court orders. Shamsuddin is expected back to Nigeria 7 days before the 20th of September 2017 when the hearing of the matter continues. Emmanuel Bagudu, PTV News.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch.
Because there's no program that is like it.
In response to the ruling by Justice John Toho on June 29, 2017, ordering stay of proceedings in the recall process by INEC to the embattled senator representing Kogi West Senatorial District, Dino Melaye, INEC have presented another application to the vacation judge, Nnamdi Dingba, at the Federal High Court in Abuja.
The Independent National Electoral Commission, INEC, through its counsel, Suleiman Ibrahim, has identified only one issue of determination in its application, which is whether the court in vacation can listen to the application. It also relied on Section 69 of the Nigerian Constitution, which mandates INEC to go on with the defendant's recall within 90 days. But the court told INEC that the Constitution is applicable only if the petition brought for the recall of Dino Melaye is correct. Representing Melaye's counsel, Mike Ezokame, is Ikem Okoro, who opposed an application for joinder coming from Anthony Adeniyi, Esquire.
We moved our application that the matter in respect of Dino Melaye's suit be heard expeditiously during the court vacation. And the Dino Melaye's counsel filed a counter affidavit to that. We have moved it, we have supplied the court with our written addresses and judicial authorities why this case should be heard expeditiously during the court vacation. In the short ruling given by the court today, the court has granted our application that the matter deserves to be heard expeditiously during the court vacation. And that's why some other people are applying to be joined. And the court has adjourned the matter till 7th of August for us to come back. But meanwhile, at least our application for the matter to be heard during court vacation has been granted today.
The plaintiff was just served with the process of the parties seeking to be joined as plaintiffs this morning, and has urged the court to give it time within which to look at the application and determine the appropriate response thereto. With regards to the application for joinder by people seeking to be joined as defendants, the plaintiff has filed his response to the application in opposition, and his lordship deems it wise to take both applications together. So the matter has been adjourned to the 7th day of August.
For Anthony Adeniyi, whose application for joinder was opposed by Dino Melaye, all is left at the discretion of the court.
If Dino and his lawyer are arguing that the petitions are forged, in Yoruba, you don't shave a man's head at his back. Of necessity, you need to invite them to sue them because they disclose their own identity. You need to sue them to say, look, the signatures you presented before INEC are forged.
After listening to the advice of Presiding Judge Nnamdi Dingba, INEC decided to accept all the applications seeking joinder so that the matter will be heard expeditiously. Justice Dingba then fixed 7th of August 2017 for proper hearing of the matter. Emmanuel Baguju, PTV News.
Chief Justice of Nigeria Walter Onogen has lauded Governor Nyesom Wike of Rivers State for his move to build the judges' quarters in the state, saying that other state governments should emulate him. The CJN spoke yesterday in Port Harcourt while performing the groundbreaking, stating that he was very elated with the project. He added that federal judicial workers from the state would also be provided with vehicles and that the judiciary should always strive to remain independent. Judiciary Watch Discuss is next, right after the break.
Keep watching Judiciary Watch for deep knowledge of the law,
Issues bordering on our collective and individual fundamental rights.
for knowing the correct perspective of the law.
Issues of governance.
You just watch Judiciary Watch.
Because there's no program that is like it.
our Discuss segment this week, we'll be looking at asset declaration in public service and its practicability in Nigeria. But before we meet our guest, we'll be looking at the background report on this issue.
An asset declaration is a person's balance sheet that covers assets, all personal belongings ranging from homes, valuables and financial portfolios to liabilities such as debts and mortgages, and all sources of income from directorships and investments to consulting contracts. It should also include gifts and sponsorship deals and any potential conflicts of interest such as unpaid employment contracts and participation in non-governmental organizations. The leadership of the three arms of government, executive, legislature and judiciary, and senior career civil servants are required by law to file asset declarations before and after taking office, as well as periodically, that is annually or every 2 years during office. Ideally, the asset declaration records exact values, but some countries opt for ranges of value. The administration of an asset disclosure program requires a monitoring and evaluation agency to collect and verify information and investigate, prosecute and sanction those who fail to comply. Here in Nigeria, the Constitution makes the declaration mandatory immediately after taking office so that there will be no further delay. The officers listed include the President, Vice President, Senate President, Deputy Senate President, Speaker and Deputy Speaker, House of Representatives, Speakers of State Houses of Assembly, members and staff of the Legislative House, governors and deputy governors of states, justices of the Supreme Court and Court of Appeal, ministers, commissioners, permanent secretaries, director generals, chairmen and members of the local councils, police, military chiefs, amongst others. Just recently, the federal government, under the leadership of Acting President Yemi Osinbajo, launched its Voluntary Asset and Income Declaration Scheme (VAIDS) to broaden the country's tax base and offer incentives for tax evaders. The scheme was backed by an executive order by Acting President Yemi Osinbajo on the following premise. Whereas the Constitution imposes a duty on every citizen to declare his or her income fully and honestly to appropriate and lawful agencies and pay taxes promptly. Whereas every taxable person is under obligation to voluntarily declare his or her income from all sources within and outside Nigeria by filing annual tax returns, computing same and paying the tax due to the tax authority. Cognizance of the desirability of inculcating in all citizens the ethics of responsibility to the nation, accountability and honesty. Aware that the federal and state governments owe citizens the duty of providing security, welfare and development in all its parameters, and consequent upon the determination of the federal and state government to provide an opportunity for taxpayers who are in default under all relevant statutes to voluntarily declare their assets and income and pay taxes due on them, in return obtain some benefits. This executive order is valid only for the period in which the scheme shall subsist and relates to only persons who have voluntarily declared their assets and income within and outside Nigeria for the purpose of ascertaining their outstanding tax liability. With this innovation by Acting President Yemi Osinbajo, Nigerian citizens interested in occupying public offices must be ready to declare their assets.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like it.
here at the law office of Johnson Jacob Usman of JJ Usman and Co. And we'll be discussing asset declaration in public service and its practicability in Nigeria. You're welcome on this episode of Judiciary Water.
It's my pleasure.
Yes, thank you. So let's just shoot right to it. So we want to know what is asset declaration in public service?
As the name implies, asset declaration means to declare your assets. That is to say, make it open what you have in terms of money, in terms of properties, asset generally. That is the simple meaning of asset declaration, to declare what you own as yours.
Okay, but for people in public service?
Yeah, for people in public service. Okay. That is what the law says.
Okay.
Not for individual in private,
okay, not
like
you
myself.
And I.
No, not. Well, I don't know of you.
Okay. All right. So, what is the law backing the need to declare assets?
Yeah, by Section 15 of the Code of Conduct Bureau and Tribunals Acts, it provides that every public officer who is appointed must declare his asset 15 months after taking the oath of office.
Okay.
And this declaration also must be done at the end of your tenure.
Okay.
4 years for those who are appointed. So, as you are inaugurated, 15 months after that, you must declare your asset. And at the end of your career, at the end of your appointment, you must also declare your assets.
Okay. Okay.
That is, so by virtue of Section 15, it is mandatory.
Okay. So for the public officers that do not declare their assets, as the law has said, what are the penalties for such?
Section 23 of the same Act has made provision for the punishment. And that section empowers the tribunal, the Code of Conduct Tribunal, now to met with that person punishment. One, if the person is found guilty, he can't be asked to vacate his office. He can also be banned from holding a public office not exceeding 10 years. That is to say, from the date of the judgment, from the date of the pronouncement, that person can be banned for 10 years. That is to say, he won't hold public office for the next 10 years. And also the tribunal has the power to forfeit the assets undeclared to the federal government. Okay. So that is the punishment.
Okay. So, well, lastly but not the least, what to you is the importance of asset declaration for public officers?
The importance of the declaration of asset is, one, to bring confidence into the populace. Two, to checkmate irregular wealth obtained by public officers. What am I saying? At the time somebody is entering to office, if you know his assets, at the end, when he is leaving, you also know his assets. You will be able to know, the public will be able to know whether that man has acquired illegal asset while he's in the office. And this brings integrity into the institution. This brings confidence into the to the public. It's a kind of checkmating illegal acquisition of asset by a public officer. For instance, if a man is entering to office where his salary is 1 million naira per month, at the end of 4 years, if the man now declare asset and his asset is running to 500 million, there's something is wrong. But if he can justify the asset acquired under the period, then the public will have confidence in either electing or appointing people into the office. So it's to give integrity into the institution, confidence into the populace. That is the main importance of asset declaration.
Okay. All right. Thank you. Thank you very much, Barrister Johnson Jacob Usman, for this educative, discourse on asset declaration.
It's my pleasure.
You're welcome once again.
It's my pleasure.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like it.
had an educative session with our guest, J.J. Usman Esquire. This is where we call it a day on today's episode of Judiciary Watch. Don't forget to drop your comments and contributions on our email and social media platforms. And remember, stay law-abiding.